my lady, just before lunch, I paused and I was about to try to address the variation on interpretation 2 that my lady put to Mr. Cohen. And that, as the court will recall, it turns on the meaning of the gas safety regulations themselves being affected somehow by the 2015 regulations. In my respectful submission, a slightly different approach is required because, as I've said, what Parliament has done is to adopt something which was already a requirement in one statutory scheme under the gas regulations, and then apply that with some modifications to the very different scheme set out under Section 21 of the Housing Act. So the starting point must be to identify, properly construed, what is the requirement in Regulation 36, and then to consider the extent to which that was modified as it became adopted as a prescribed requirement. And my submission is there's nothing surprising about Parliament simply taking that requirement and applying it in the way that I say it has done to the Section 21 regime. Parliament must have been entitled to legislate on the basis that landlords have not committed a breach of a regulation which is punishable by criminal offence under an existing statutory regime. And turning to the 2015 regulations themselves, Lordships and your ladyship can reach for the authorities bundle again and turn up tab 8. And if we start with Regulation 1 on page 108. Now, I accept that in Regulation 1, Parliament has, or the draftsman rather, has put in an opt-out, and that is in Regulation 1.4, which there was some discussion about earlier. So that over on page 109 follows from paragraph 3, which says, subject to paragraph 4, these regulations apply in relation to an assured short-hold tenancy of a dwelling house granted after or on or after the 1st of October. So the carve-out in Regulation 1.4 is that these regulations do not apply to an assured short-hold tenancy that came into being under Section 5.2 of the Housing Act 1988 on or after the 1st of October 2015, on the coming to an end of an assured short-hold tenancy that was granted before that date. So to that extent, landlords under a tenancy which came into being prior to the prescription of this as a requirement have a degree of protection. But the interesting thing about this, of course, is that it was only intended to last for 3 years. And I take that from the Deregulation Act, Section 41, the tab forward in the authorities bundle behind tab 7, and it's on page 101. So this is an important section of the Deregulation Act. It deals with the application of sections 33 to 40, and of course it was section 38 which inserted section 21A into the 1988 Act. And what we see from section 41, subsection 3 over the page, is this important proviso, which says that at the end of the period of 3 years, beginning with the coming into force of a provision of section 33 to section 38 or section 40, that provision also applies to any assured short-hold tenancy of a dwelling house in England which is in existence at that time and to which that provision does not otherwise apply by virtue of subsection 1 or 2. Subsection 1 or 2 and 2 are the matters, I think, which then give the regulation making power in Regulation 1.4 to carve out, 1.4 to carve out statutory periodic tenancies which arise on the coming to an end of an assured short-hold tenancy granted before 1st of October 2015. The reason why this is important is because in my submission it powerfully tells us that Parliament in fact did intend that after 3 years, landlords under statutory periodic tenancies arising before the 1st of October 2015 would be caught by the prescribed requirements, notwithstanding the provision back in the 2015 regulations on page 109.
But Hathaway tells us, well, My understanding is that Hathaway tells us that that really didn't take effect because no regulations were put in place. And my point is not about the interpretation of the Act, it's about the interpretation of the regulations.
I see, my lady.
And
one observation.
specifically Regulation 1 sub 3, not 1 4.
Yes. But 1 sub 3 is, of course, made subject to
Yes,
sub 4.
indeed.
And sub 4 seems to me might be thought to run headlong into the express provision in the main Act, section 41, which provides that after 3 years, the prescribed requirements will apply to all tenancies in existence.
But I thought that was the argument that was rejected in Hathaway.
As I understand in Hathaway, what was actually put was about, or it was decided on the basis that Parliament had not exercised a power to make a regulation.
The Secretary of State had.
Sorry, the Secretary of State, of course, hadn't exercised a power essentially to tweak that regulation. And so what was an issue was the extent to which the regulation applied, not the main Act. But what is interesting is that the main Act, section 41, does contemplate that this would only be a 3-year thing, and then it would cease to have that carving out effect.
But I thought the reasoning in Hathaway was that because all the primary legislation does, in essence, is confer regulation-making powers, section 41 sub 3 was effectively left without teeth. The tenant couldn't get home on it.
Indeed, and I'm not suggesting here that I need to rely on this to get home. The reason I light on it is because what it tells us about Parliament's intention in enacting this scheme is that there would only be a 3-year period throughout which the opt-out at 1.4 would apply. The fact that Parliament decided, for whatever reason, that it wasn't, or the draftsman, or the Secretary of State rather, decided not to make regulations to give effect to what Parliament's clear intention was in section 41 of the Act. We don't know why that is. But certainly looking at the scheme and looking at the 2015 regulations through the lens of the primary legislation which created the regulation-making power, we do see a clear parliamentary intention that the regulations would, after 3 years, bite even on tenancies which arose on the termination of tenancies granted before 1st of October 2015. And so what that tells us is, in fact, that Parliament, or the regulations at any rate, they were concerned with what had happened in the past, because why otherwise Regulation 1.4. But what we get when one looks at the scheme as a whole and the 2015 regulations is that Parliament and the draftsman regulations have clearly turned their mind to what is to be excluded from the effect of the Act. All of these things, sorry, the effect of the regulations, all of these things can be taken to be deliberate decisions and not some omission to exclude a landlord of a tenant who first went into occupation under a tenancy before the 1st of October 2015. And just to try to make that point good again, if we look at Regulation 3, for instance, which is page 110. So this is the requirement for the landlord to provide the prescribed information. So this is the how to rent guide that Mr. Cohen referred to earlier. What we see at Regulation paragraph 5, that Parliament's made a decision to disapply the effect of this prescribed requirement where the landlord is a private registered provider of social housing, or where the tenancy, the new tenancy, is a replacement tenancy. And it tells us that replacement tenancy has the same meaning as in section 21, subsection 7 of the Act. Just very quickly, remind ourselves what that says. It's on page 30. So subsection 7 of section 21 is what we're looking at, and that defines a replacement tenancy as one which comes into being on the coming to an end of an assured short-hold tenancy, and under which, on its coming into force, the landlord and tenant are the same as under the earlier tenancy, and as it's coming to an end, and the premises let are substantially the same. Same or substantially the same. And so coming back to the reference to replacement tenancy in Regulation 3.5, back on page 110, there is a conscious decision here to carve out, from a different regulation I accept, tenancies that come into being after an earlier tenancy. And the reason I place reliance on this is because in my submission what we have within this regulation is a coherent scheme with the draftsman consciously turning their mind to how all of this is to apply to existing situations, carving out certain things but not others. But what unambiguously we have at Regulation 1.3 is a proviso that applies the effect of Regulation 2.1b to any assured short-haul tenancy in existence on or after the 1st of October 2015. And so my response to my lady's point is that actually it would require, in the context of this scheme, wording actually to be added to the 2015 regulation to have that effect. And Parliament, it can be taken in my submission to have chosen to omit that wording. And in any event, were this genuinely thought to have been an issue or to have created an issue, it would have been something one might have thought that it would have picked up on one of its reviews of the regulations if that in fact happened under Regulation 5.
But as I understand it, what you're saying is, well, look at Regulation 3 sub 5. There the draftsman has made a conscious decision to carve out so-called replacement tenancies.
In a different context.
But have not done so.
Yes.
In the context of Regulation 2.
Indeed. And all this tells us, what this tells us, is that Parliament would have understood when it enacted this regulatory scheme that things might have happened in the past that might be relevant to the scheme, which presumably is why it included Regulation 1.4 and said these prescribed requirements don't apply where the statutory periodic arises from a tenancy that had already been granted. But what I do finally, just to try and wrap this up, I pray and aid a paragraph quoted from Lord Simon's judgment in the Stock and Frank Jones Tipton Limited case, which is reported at 1978 One Weekly Law Reports 231. I've quoted it in my supplemental skeleton argument in the Muca appeal. I'm afraid it's not in the bundle, but I believe that's because the proposition is not in dispute. But if I can show you where it's where I've picked it out, it's in my second skeleton in the Muca appeal, so it's behind tab 8. I think Mr. Cohen's got this. Yeah. And it's page 78. I'll just invite the court to read that paragraph quoted. And also, if I could just refer to some other paragraphs in my Lord Justice Newey's judgment in the Adriatic Land case, that's in the authorities bundle behind tab 19, in the section where His Lordship summarises the principles relating to retrospectivity. We could go to page 408. And paragraph 57 at the bottom of that page. As Lord Reid pointed out in AXA General Insurance Limited and HM Advocate, a distinction might be drawn between laws which alter prospectively the rights and obligations arising from pre-existing legal relationships and laws which alter such rights and obligations retrospectively. And His Lordship then referred to the example from Western Gwyn, the judgment of Lord Justice Buckley, just over the page, very end of that quotation, which I'd like the court to read, the final sentence of the quotation I say is very important to this case because Justice Buckley explained that there is no like presumption that an act is not intended to interfere with existing rights. Most acts of Parliament, in fact, do interfere with existing rights. And then my Lord Justice Newey, at paragraph 58, identified that the same distinction can be seen in the Wilson case, which is in the bundle, and there Lord Hope said that the concept of fairness and legal certainty carry much greater weight when it is being suggested that rights or obligations which were acquired or entered into before the 2nd of October 2000 should be altered retrospectively. And then at paragraph 161, Lord Scott made this comparison. If a lease is granted for, say, 99 years, there might well be intervening legislation capable of affecting the ability of the landlord to forfeit the lease, to operate a rent review clause, to claim damages for dilapidations, or to recover possession on the expiry of the term. But it would be unusual for the legislation to alter the rights and obligations of the parties resulting from events that had already taken place, such as a forfeiture notice already served, a damages claim already instituted, rent review machinery already in train, and so on. And then my Lord also quoted at paragraph 59 from the judgment of Lord Justice Patton in the Granada UK rental case, said, no one can expect the law to stand still. It must react to changing circumstances and problems as they unfold. Clearly, legislation which removes or alters already accrued rights is likely to be more objectionable and therefore unfair than legislation which imposes a new liability based on past conduct. And the reason I refer to those passages here will be obvious in the context of construing the 2015 regulations. Because what I say, as I anticipate in opening, is that the different application of the regulations at their outset to a landlord under an assured short-hold periodic tenancy which arose prior to 2015 and a landlord under a replacement tenancy granted after 2015 is something which the draftsman can have been taken to have been aware of. It can be seen as a rational policy decision made by a rational legislature. And also, we see, it's a point trailed earlier, now that Section 2 of the Renters' Rights Act has deleted the entirety of the chapter from the 1988 Act, which actually creates or sets out assured short-hold tenancies and makes every tenancy an assured tenancy, it can hardly be suggested that doing so on a I can't remember how my Lord Justice Newey put it earlier, to a subset of tenancies back in 2015 is somehow so irrational, so absurd, so offensive that Parliament can't possibly have been taken to have intended it. And as Mr. Cohen threw me under the bus to try to address the transitionals, I had a quick look over lunch. I'm afraid I didn't get much further than the very helpful summary on the shelter website. But what that does make clear is that if you have served a Section 21 notice before the abolition of the assured short-hold tenancy in a few weeks' time, beginning of May, I believe, you are still entitled to rely on that Section 21 notice. However, you have, I think, 6 months from the date of your notice to serve, to issue proceedings, or 3 months from the date on which the abolition takes effect, whichever is the later. So there is.
And then you can't serve a Section 21 notice at all.
Exactly.
After the date.
And it's a useful example, my Lord, of what we've just been seeing in the quotations from the Adriatic Land case, because here we've got Parliament abolishing the right to rely on Section 21, but introducing a transitional provision that makes sure that it doesn't have a retrospective effect on people who have already served a valid Section 21 notice. But for those landlords who are in a relationship of landlord and tenant, which is an assured short-hold tenancy, who haven't served Section 21 notice by the time limit, well, although their rights arose under an agreement that they entered into a long time ago, perhaps, they won't be able to, in the future, serve a Section 21 notice. And that's a perfectly legitimate and rational way of legislating. So that is all I've got to say in response to my lady's variation on interpretation 2. I was then going to come on to Trecarrel. I think, though, you'll have seen that my case is that Trecarrel provides a complete answer because it is binding authority that none of the 3 interpretations advanced by Mr. Cohen are open to this court. I've addressed that thoroughly in my skeleton argument, and unless...
Just to be clear, do you say that we are actually bound? I mean, you said binding a moment ago. Do you say that we are bound by Trecarrel to reject one or more of the interpretations?
I do, my lord. Let me briefly explain why. We can just go to Trecarroll. The ratio we find, so paragraph 30 on page 255. Sorry, this is behind tab 14. So the ratio of Trecarroll in my submission is that.
Sorry, you say the
Paragraph
ratio is
30, my lord.
paragraph 30.
From Lord Justice Patton's judgment, and expressed in my submission more clearly on page 258 in Lady Justice King's judgment, paragraph 43, 5, little Roman 5. So what is clear from the reasoning is that both regulation 36.6a and 36.6b are prescribed requirements. And on the facts of that case, the reason why the appeal was disposed of as it was, which was allowed provisionally but remitted to the county court for a factual finding to be made about whether a document had been served before the section 21 notice, was that the court was satisfied that regulation 36.6b had been complied with as a result of late compliance. So that was fundamental to the decision, that finding, and also then that the appeal would be allowed if regulation 36.6a had been complied with, that being a factual finding to be remitted to the county court of Truro. So it is part and parcel of the ratio of this decision that a landlord can only rely on a section 21 notice if it has complied with regulation 36.6a and 36.6b. That requires it to provide at least two records, the pre-occupation record and the last record made under regulation 36.6a, before it can serve a section 21 notice.
Does that depend actually on how long the...
My lady, I'm sorry, yes, of course it will. So
it's not always going to be two, is it?
It's not. In this case it was because of the length of the term, but I accept that in fact regulation 36.6a might not actually have been engaged over the course of, say, a 4-month tenancy or a 6-month tenancy. But where, as here, the total term of the tenancy exceeds a period of time so that both regulations have been engaged, they are both a prescribed requirement.
Well, which tenancy exceeds the period? Each tenancy was only 12 months, wasn't it?
Yes, sorry, but when the total duration of the period, for the purposes of interpretation 1 for the moment, we're assuming that occupation means the first time a tenant went into occupation. So if from that date until the date of the section 21 notice, there's a long period of a landlord and tenant relationship, regardless for a second, the time being of how many different leases had come into existence, then regulation 36b would have been engaged on my case and the judge's construction before the tenant first went into occupation, and thereafter regulation 36.6a takes over. But the ratio of Trecarroll is that in such a case, both of those requirements are prescribed. And if it were the case that in fact, as Mr. Cohen submitted, it's just the later record produced under either 36.6b or 36.6a that must be provided, then the only question for the court would have been whether the later gas safety record had actually been served on Ms. Rounsfield before the section 21 notice. And the court wouldn't have needed to have been troubled by the regulation 36.6b preoccupation GSR.
But did the facts of Trecarroll straddle of the coming into force of the 2015 legislation?
No, my lord, they didn't.
Well, if that's correct, speaking for myself, I don't see how Trecarroll can be, strictly speaking, binding on this court, because it's not, strictly speaking, addressing the very issue that we have to decide.
Okay, my lord, I accept that. But in order for there to be a way of that ratio somehow not applying to the facts of this case, there would have to be something somewhere in the statutory wording which would enable the court to find that it doesn't apply to a case where the tenant originally had gone into occupation prior to 2015. And that I submit, we don't have. Mr. Cohen's interpretation 1 simply says, looking at the 2015 regulations, it is the last record made, or the relevant record. It relies on the singular wording to say there is only one record in every case that must be served. And that, I say, doesn't work, and that's not the ratio of Trecarrell. And then on interpretation 2, when one looks at the facts of Trecarrell, one finds, in fact, as I've tried to flag in writing, she went into occupation, we're told, in the first paragraph of the judgment on page 245. So she went into occupation for a period of 6 months, fixed term of 6 months. So that term expired on the 20th of August 2017. We don't know whether she was then granted another fixed term tenancy or whether a statutory periodic tenancy arose under section 5.2. But either way, what would have happened as a matter of law at the expiry of the fixed term was that a new lease would have come into existence for the purposes of Regulation 36. Because you'll recall that Regulation 36 of the gas regulations excludes from the definition of statutory tenancy, or rather it only includes within the definition of statutory tenancy a rent act tenancy or certain agricultural tenancies. So it would be a new lease. So on the facts of Trecarrell, Ms. Rounsfield was in fact in occupation under a second lease on the date on which the Section 21 notice was served. And what the court was concerned with was whether she had been served with the pre-occupation GSR from the date before she first went into occupation. And one gets that when one reads through the decision, and I've tried to flag all of the passages in writing. One also takes it from the head notes at 243. And what is said is that the landlord failed to give the tenant a copy of the latest gas safety record prior to her taking up occupation. Now, on the facts of that case, I accept that the gas safety record, which ought to have been given before she first went into occupation, was the same as that which ought to have been given on Mr. Cohen's case before the springing into being of the new lease after the fixed term expired, because a period of 12 months had not passed, and so an obligation to create a fresh certificate hadn't arisen. But on the facts of that case, my submission is that the Court of Appeal nonetheless decided that the relevant period of time for construing Regulation 36(6)(b) is before the tenant goes into occupation. And one were to ask the question, well, what would the Court of Appeal have said if in fact Ms. Rounsfield had been in occupation for a lease of, say, 12 months, so that a fresh record had been created? Would the Court of Appeal then said, well, it doesn't matter that you didn't give the record before she went into occupation, before she took up occupation? It would have said, no, that is still the relevant record that would have had to have been provided under Regulation 36(6)(b). And that is clear from all the passages in the judgment where their lordships and her ladyship said there's a distinction between someone who is in occupation from year to year and the time before someone first goes into occupation, and the clear policy, the distinct policy reasons that their lordships and ladyship identified for Regulation 36(6)(a) and 36(6)(b). 36(6)(b) is about giving someone who is a prospective tenant an assurance, in the words of His Honour Judge Luber KC, quoted in the judgment, an assurance that the property is safe before they go in, and thereafter it's about repeating that assurance from year to year.
How far does it matter if the points which Mr. Cohen is advancing weren't really raised in Trecarrell?
Well, that doesn't, in my submission, make the decision in per curiam, because under Young and Bristol Aeroplane Company, a decision's not in per curiam just because some relevant provision wasn't referred to the court. It's only in per curiam if the decision was reached in ignorance of some other binding authority, and there was none. So that would be, in my respectful submission, a matter for another day. And on interpretation 3, well, that just doesn't work in my submission because it again, in a tenancy such as in a landlord and tenant relationship which has endured for over 2 years, the effect of it is to disapply the requirement in Regulation 36(6)(b), and that was expressly rejected as a possibility by the Court of Appeal in Trecarroll.
Does it follow from that submission that Judge Melissa Clark was wrong?
I do say, with greatest respect to Her Honour Judge Melissa Clark, that she was wrong, and this was dealt with very respectfully by His Honour Judge Hellman in the judgment below, which you'll have seen, because he had this case before him, and he explained carefully why it was that he thought that he wasn't going to follow that reasoning. So I do say, with the greatest respect, that Her Honour Judge Melissa Clark was wrong on this point for the reasons that His Honour Judge Hellman elaborated on below.
Yes, I understand the submission, but the reason it matters, whatever the outcome of these appeals is, because we're the Court of Appeal, if we agree with you about that, then we would be overruling that decision, whereas a court of coordinate instance can't do that.
Indeed, yes, yes. And to that extent, I would invite the court to prefer the reasoning of Her Honour Judge Tracy Bloom in the Byrne case, which is also at the back of the bundle. And His Honour Judge Hellman recognised that there was some tension between the two cases at the very least, if not that they were completely irreconcilable, and he recognised that that was something which might be resolved by a higher court. And so here we are before your lordship and your ladyship today, inviting you, I suppose, to do that. Yes. Just lastly on Trecarroll, before I move on, can I just say something about the respondent's notice argument in Trecarroll, because it was again ground that was traversed earlier. This, in my respectful submission, is a trickier part of this judgment, and indeed that was recognised by Lord Justice Moylan in his dissenting judgment, because what he said in the very last paragraph on page 262, paragraph 64 of the judgment, this is a new argument not advanced below, it's a pure question of law. For the reasons set out by Lord Justice Patten in paragraph 35, it is difficult to see how Regulation 36 would be workable. The argument was right. However, as this was not raised below and was, with respect to counsel, argued as a subsidiary point, and given its importance, I would prefer to wait until it is properly and substantively raised and argued before finally deciding the point.
Sorry, where are you reading?
My lady, I'm sorry, that was the last sentence of Lord Justice Moylan's judgment in Trecarroll, page 262 of the bundle.
Okay.
So what, nonetheless, we can take from the reasoning of Lord Justice Patten, with which Lady Justice King agreed, is that where a record which has been created, which the obligation in Regulation 36(6)(a) would bite, i.e. if you've made your record after the start of a tenancy, so it's a subsequent check, the existing tenant obligation is engaged, you must do it within 28 days. What Lord Justice Patten has decided is that if that record exists, it must be provided under Regulation 36(6)(a), even if it is created late. But where that opens up a possible difficulty is that it begs the question, well, what happens if, in fact, the landlord doesn't do any checks at all throughout the term? There's no record that they can produce. If they can simply make that good by doing it late, even if it's 10 years late, that amounts to belated compliance, it seems, for the purposes of the 2015 regulations, with what they have to do. My submission then, given that the court obviously should prefer a construction that is not open to avoidance, what really this decides is that if no check is carried out, so that no record can be provided, then you can't possibly comply with Regulation 36(6)(a), and you can't then rely on a Section 21 notice. So going back to the 1998 regulations, behind tab 6 on page 84. So Regulation 6 is, notwithstanding paragraph 5 above, every landlord shall ensure that a copy of the record made. So my submission, what Lord Justice Patton has decided here is that there is an obligation to bring a record into existence and give it to the tenant in order to comply with the prescribed requirements. It doesn't matter if that is created late. What I accept that means, of course, is that you can breach your duties throughout a long period of a landlord and tenant relationships by not carrying out any check at all, provided you belatedly do your annual check before you serve the Section 21 notice.
And sorry, just going back to something you said a minute ago. So suppose you do a check and you lose the record and can't get a replacement or whatever. Can you still just do a later check and provide that?
Well, in respect of that gas safety record, it would seem that you're in the same position as the landlords in this case. You can't make good that breach within Regulation 2015 regulation terms because you haven't got the record that you can belatedly provide. But in this case, yes, I accept that you can get yourself back into a position where you can serve Section 21 notice, not say by remedying your earlier breach, but by carrying out another check, creating another record, and then providing that to the tenant before you give the Section 21 notice.
So you do accept that, provided on your case you've met the pre-occupation requirement, separate point, during the currency of the lease, landlord could fail to get any checks done until shortly before they decide they want to serve the Section 21 notice.
Yes, they can't do that from the point of view of the regulations because they're in breach of the regulations, but for the purposes of prescribed requirement, I accept, yes. That is the effect of the respondent's notice analysis in Trecarroll. But I wouldn't go so far as to say all you need to do is to serve the latest record made. You've still got to serve records in respect of all of the checks, because that's what Regulation 36(6)A requires you to do. If there is a record, then you've got to provide it to the tenant, and if there's a record and you haven't provided it to the tenant, you must do that before service the Section 21 notice.
It's probably isn't worth exploring too much further. So you carry out a check, you get a record, you don't serve it. You think, well, maybe it's lost in a drawer somewhere. Well, can you then say, well, I'm not going to spend all my time searching for this record that may or may not still exist. I'll just do a new check.
My lord, I'm sorry, yes. Can I think what I said earlier about this, I misunderstood the point that's being put. No, if there is a record and it's been lost, well, nonetheless, there is a record, you're under an obligation for purposes of Regulation 36(6)A to provide it. That is a prescribed requirement. So if you can't provide it, because it's not just lost in a drawer, it's gone forever, then that is the same sort of breach that we're looking at here, which is something that you can't cure.
So a landlord is better on that analysis, better off totally defaulting, not conducting any checks at all, and just getting a check done before they want to serve a Section 21 notice.
Again, through the eyes of the 2015 regulations, that is, it seems, the rationale of, or the message, the take-home for landlords as a result of the respondent's notice in Trecarroll. Not, of course, through the eyes of the 20...
When you say the respondent's notice, to be clear, I know Lord Justice Moylan didn't pick that up, but the majority did. It is the consequence of the majority decision.
It is, yes, I accept that. I'm dealing with this slightly hesitantly because it is not directly relevant to what this court's got to decide about the separate regulation, Regulation 36(6)B, and the extent to which that is prescribed.
Indeed, but we are looking at, we are obviously bound by Trecarroll, and we're looking at the 2015 regulations through those eyes, as it were.
Indeed, and I accept the court is bound on this, and I suppose I should reserve my position on the correctness of that bit of the decision in Trecarroll if this were to go further. It's not a part of the decision which has been without some criticism in the world, as it were, but it is the effect of the reasoning in that case. Yes, accept that. But what I say nonetheless about Regulation 36(6)B is all consistent with that, because these are got an obligation to do something under the 1998 regulations. That's a breach of the regulations if you don't do it. The prescribed requirement is that you've either done it already, and if you haven't, then you're entitled to do something later and bring yourself belatedly into compliance with something. So the way that the spur to compliance of section 21A and the regulations works might be uneven, perhaps, in practice. But again, going back to all the submissions I made earlier about consequences, anomalies, and rational legislature, nonetheless, this is what the language of the legislative scheme indicates that Parliament intended to do. So that's all I'm going to say about Trecarroll. And lest I'm not right that it's binding on this court in any respects in respect of interpretations 1, 2, or 3, let me say something about the language of the scheme itself, starting with interpretation 1. So for this, we just need to look at the 2015 regulations back behind tab 8. And on page 109. So the basis of the linguistic submissions is that the regulation uses grammatically singular phrases to talk about a gas safety certificate, the relevant record, the requirement. And there's a very simple explanation for why the grammatically singular sense is used. That is for the simple reason that regulation 2(1)b prescribes as a requirement both limbs of regulation 36(6). So in context, the singular reference cannot be so limited grammatically because regulation 36(6) creates multiple obligations to give a gas safety record. But that, in my submission, is the linguistic key to unlocking this. Each of the obligations in regulation 36(6) is to give a single document. That obligation to give a single document is capable of arising again and again after a 12-month period. So every time an obligation to carry, or every time a further check has been carried out, then a new obligation to give that singular record arises. So in my submission, all of this fits together. There's no tension in the singular grammatical phrasing in regulation 2. One can take that point slightly further if one actually looks at regulation 36 itself. And this time at regulation 36(7) on page 84. There, the draftsman has used the singular sense, even though it is clear that multiple records are in contemplation by the regulation immediately before. So where there is no relevant gas appliance in any room occupied or to be occupied by the tenant, the landlord may, instead of ensuring that a copy of the record referred to in paragraph 6 above is given to the tenant, ensure that there is displayed in a prominent position a copy of the record. And indeed, this was all explained by Lady Justice King in Trecarroll. If we can go to page 258. Paragraph 43(5), little Roman 5. What she explains simply is that something in relation to gas safety records is found in regulation 2.2 and is to give a copy of the relevant record to the tenant and applies by its specific reference to regulation 2(1)b of the 2015 regulations to both regulation 36(6)a and b. So the relevant record is the record under regulation 36(6)a or the record under regulation 36(6)b. And any doubt about that in my submission would be dispelled by the application of section 6C of the Interpretation Act, which provides that a singular includes a plural unless the context requires otherwise. And in my submission, there's nothing in the context here to require otherwise, quite the contrary. So linguistically, interpretation 1 in my submission involves an artificial construction. It involves placing far too much weight on words in the singular in an attempt to lock out a meaning which in context is plainly plural. So on to interpretation 2 now. The judge's construction of regulation 36(6)(b) involved in my submission giving a very straightforward meaning to the word occupation. Accepting what was common ground below, he directed himself that occupation related to the first point in time where a tenant went into physical occupation of the demised premises. And he directed himself correctly in my submission that regulation 36(6)(b) is directed to that moment in time. And thereafter, a tenant becomes an existing tenant within the meaning of regulation 36(6), and therefore they fall within the scope of regulation 36(6)(a). If we can just go back briefly to the regulations, the gas regulations, back on page 84. What we see first of all is regulation 5, the record referred to in paragraph 3c above, or a copy thereof, shall be made available upon request and upon reasonable notice for the inspection of any person in lawful occupation of the relevant premises who may be affected by the use or operation. So it is about physical occupation, because that is what crystallises an interest in the safety of the gas appliances in the premises. My submission is that once you are in lawful occupation, regardless of the basis of that occupation, you are entitled then to request inspection of the record. And regulation 36(6)(a), which comes first in time, arises where there is an existing tenant of premises and someone is an existing tenant as a matter of ordinary English, where they are in possession of property under a lease. In my submission, they do not cease to be an existing tenant simply because the fixed term has expired, the statutory periodic tenancy arises, or a new fixed term tenancy is granted. It doesn't make sense to talk of them as a new tenant, as distinct from an existing tenant, because their status as a tenant is legally unchanged, and their factual status as an occupier is also legally, factually unchanged.
Is that so even, for example, if they change from a licensee to a lessee?
Well, if they
the
change,
definition of tenant includes
it does, yes. So if someone changes from being a tenant to being a licensee, they are still an existing tenant within the meaning it is given in the regulation, either tenant or licensee, because they are already in occupation as either a tenant or licensee. So in my submission then, regulation 36(6)(b) has to be doing something different. If it doesn't apply to existing tenant, then the question is, well, what is a new tenant? The clue is before that tenant occupies those premises. A new tenant is someone who has yet to take up occupation of the premises as a tenant. It's about the physical moment in time when they go into possession, thereafter they become an existing tenant. And so the judge's straightforward interpretation requires no words to be read in at all. I don't accept the submission that it does. Occupies those premises involves simply something happening in respect of premises. It identifies a point in time. Once that thing, that happening has been done, the person is then in occupation of those premises. And so the word before in regulation 36(6)(b), without any words needing to be read into it, simply means before that action takes place, before that person occupies, before that person goes into occupation.
So can I just explore that for a moment? Before that person goes into occupation as a tenant, that's the position on your construction, is it?
Yes, my lord. And I say that because obviously Mr. Cohen points out, well, supposing you're already in occupation lawfully, but not as a tenant within the meaning of the regulation. And I say, well, there's no obligation at all at that point to have a gas record produced. But as soon as you are contemplating becoming a tenant within the meaning of the regulation, so a tenant or licensee under a qualifying lease or license, at that point the landlord under regulation 3B has got to make sure that they get the gas safety record, because they must do that 12 months before, in a period of 12 months before you become a lessee or a licensee, a lessee for the purpose of the regulation. And so yes, the key point in that situation is that it is when you first go into occupation as a lessee.
But picking up the point earlier, if you were previously a tenant, made earlier I think, if you were previously a tenant for a period of longer than 7 years,
Yes.
and then let's say you have a 1-year lease granted after that, how would you say that this applies?
So there is no obligation when you're before the 1-year lease is granted. No obligations at all. The regulations simply aren't engaged at all in respect of your occupation. But there comes a moment in time where regulation 3B will be engaged. So that's the obligation before a lease commences to get the gas safety check done and to produce the record. So the only sensible way in that situation where someone's lawfully in occupation but not yet a tenant within the meaning of the regulations is to say, well, fine, but the landlord, in advance of you becoming a tenant under the regulations, has got them to cause a record to be produced.
Yes, but that's not the same as what you described as the judge's straightforward interpretation of occupation meaning physical occupation. You are
Yes.
putting some,
So, yes.
you're qualifying it quite a lot.
I accept that, my lady. What it means is occupation, before they go into occupation for the first time as a tenant. Now, I accept that it's a little bit bumpy to try and make that work where someone is already in lawful occupation. But nonetheless, it still works. It still makes sense. The landlord's obligation to give the record can still arise before that person actually becomes a tenant within the meaning of the regulations. It must do because of regulation 3B, which tells the landlord that there's something they've got to do before a lease commences with that time. And in the hypothetical that my lady's putting to me, you've got someone who's in the premises, but not as a tenant under the regulations. And so the landlord hasn't had to do anything under the gas regulations, hasn't had to cause any record yet to be produced. But the way that this works is that at some point in advance of the tenant becoming a tenant, the landlord's going to have to do this. They can't, without breaching their obligations under the regulations, grant a tenancy without making that record be created. And in that, perhaps, might be thought a slightly rare situation where someone is granted a tenancy within the meaning of the regulations who's already been in lawful occupation beforehand. I don't think that's going to be a particularly common eventuality, but in that eventuality, my submission is, well, provided you've given them the record before they are in occupation as a tenant, then you've complied. But in every other case, and thereafter, my lady, I nonetheless maintain that once that's happened, you are then an existing tenant within the meaning of the regulation, and so you're then into regulation 36.6a and out of regulation 36.6b. So it's not the smoothest, I accept that, but it does work.
And I know you've said this more than once, but for the purposes of your analysis, you could be an existing tenant through successive tenancies.
Yes, indeed. Yes, because you are. It doesn't make sense to talk of someone when, if I've got a tenant of a flat, I grant them a new tenancy. They are my existing tenant. I've granted a new tenancy to my existing tenant. There is a new tenancy, but they are in no sense a new tenant. And their status, if you like, is as a tenant, regardless of whether it's under tenancy A or tenancy B. And conspicuously, as my lady put to Mr. Cohen earlier, the draftsman did not say before the lease commences in regulation 36.6b, notwithstanding the use of that phrase in regulation 3b. So in regulation 3b, the draftsman has made a conscious decision to tie the timing of the obligation to make a record to point in time before the lease commences. In regulation 36.6b, it's just before occupation. And
why is that? I mean, turning it the other way around. So one sees at the 6B stage, a conventional situation would be, look, there's a tenancy, but the tenant hasn't yet gone into occupation, so he doesn't yet need to have the record. And why doesn't the same approach then apply to 3B? Why do they want the check to be done before the lease commences? I don't know. Still, perhaps it doesn't matter.
Well, perhaps one was to do with the interplay with 3A and 3B. So 3A is the obligation to make sure something's checked in intervals of 12 months. 3B says that if that obligation hasn't yet arisen, you've got to do it within a period of 12 months before these regulations are engaged by anyone occupying your premises.
Yes, but it might suggest that Draftsman wasn't really consciously drawing a particular distinction between 3B and 6B, more effectively drafting convenience. The most obvious date to fix on 3B. So, I mean, earlier you were using 3B to support your construction of 6B, and now you're distinguishing it.
Well, I'm using it to
say I'm. It's not intended as a criticism because I'm finding this not at all straightforward.
So the reason why I said the judge's interpretation is straightforward is because it is, perhaps if I put it like this, it is capable of being given effect to linguistically without reading any words in. Occupation just means occupation. Before the tenant occupies premises means before the tenant has gone into occupation. That is the way that it was analysed, the wording was analysed intra-carol, before the tenant takes up occupation. And that is why I say it's straightforward, because as Mr. Cohen I think accepts, his construction does mean reading words in. It does involve reading in the words, as he put it. It's occupation pursuant to the new lease under which that person is a tenant, or words to that effect. But here, a decision in contradistinction from 3B, which is tied to commencement of a lease, the different concept of occupation is used. And at this point, I might just draw attention on, I don't say it's determinative. If one looks at the claim form, the standard assured short-hold tenancy accelerated possession proceedings claim form, which we find at tab 12 of the core bundle in the Harker and Hughes appeal. And particularly 138, page 138. If we look at box 17A, the question asked of the landlord when they're filling in this form is, was a copy of a valid gas safety record provided to the defendant before they went into occupation of property? As I said, don't submit that that's determinative, but natural meaning of went into occupation is at least consistent with what the judge understood occupation to mean. My submission, a reasonable reader, reasonable landlord reading this form would understand that what they had to do was to say, before this person physically went into occupation of these premises, I gave them a record, not before they went into occupation under this particular tenancy, I gave them a record. Mr. Cohen raises a number of absurdity arguments in his skeleton. I'll just rely on what I've said in writing, although I think I have covered extensively one of those now. But there's just one absurdity argument I might raise back, if I may. If we suppose a landlord, before the grant of an original tenancy, failed to cause a gas safety record to be created, and failed to do that before the fixed term expired and it became a periodic tenancy, the only way for the landlord then to remediate that breach and get themselves into a position where they could serve a Section 21 notice.
You're going a bit fast. I'm not keeping up.
Sorry, let me slow you down. So, take a landlord.
Yes.
The landlord grants a 6-month tenancy. Before that, he doesn't get a gas safety record.
Yes.
At the end of 6 months, the statutory tenancy becomes, the tenancy becomes a statutory periodic tenancy. So it's now rolling forever and until it's brought to an end. Before that happens, the landlord also fails to get a gas safety record. So there's now an assured short-hold tenancy. that no gas safety record was ever produced before it came into existence. The only way that the landlord could then get themselves into a position of being able to serve a Section 21 notice, in Mr. Cohen's case, would be to encourage the tenant to give up their statutory periodic tenancy and accept a new fixed term tenancy and make sure that they gave them a gas safety record before that happened.
This is all post 2015.
Yes, let's assume it all happened post 2015, but I'm just addressing here interpretation 2, which is all about how the meaning of occupation in regulation 36(6)b. So that, I suggest, is an overly elaborate way, even on Mr. Cohen's case, of achieving a remediable result. And it could obviously be frustrated then by the tenant simply saying, well, I don't want to give up this assured short hold periodic tenancy. I don't want to take a new fixed term tenancy because I know you're doing this just because you want to be able to serve a Section 21 notice and you can't already. So it's just an illustrative, perhaps, absurdity that arises the other way. And the final thing I had to say on interpretation 2, linguistically, is that it wouldn't make any difference to the outcome of the appeal. And I say that because on Mr. Cohen's interpretation, regulation 36(6)b, it's converted essentially, or instead of it being a one-time obligation, as I say it is, it's converted into a rolling obligation, and it arises afresh every time a new tenancy is granted. So like 36(6)a arises after every subsequent gas safety check, the obligation would arise anew under regulation 36(6)b each time there were a new tenancy. But even if that is right, so even if the landlord under regulation 36(6)b was required to have given a gas safety record before the start of the latest fixed term tenancy, it would leave intact the obligation to have done so before each of the earlier tenancies as well. And so working backwards, the landlord would still have been under an obligation to have provided the last gas safety record made before that tenant first went into physical occupation as a tenant. I'll just pause there because this is important and I want to make sure that
I'm not sure I quite
everyone's
got
noticed
it.
it.
You're saying that historic breach in relation to other tenancies, earlier tenancies,
So
affects the ability to end this tenancy under interpretation 2.
I'll come to that, but let's just start with regulation 36, back on page 84. So I say the obligation under paragraph 6b arises once before the tenant goes into occupation for the first time. Thereafter, A takes over. Mr. Cohen says, well, it does arise before the tenant first goes into occupation, because it's before they become a tenant under the lease pursuant to which they're a tenant, but it then arises again and again and again, each time there's a new tenancy.
So in this case, a dozen times or whatever it is.
In this case, yes, a dozen times, many times. But the point that I make is that the landlord, well, A, that seems to impose more obligations, perhaps on a landlord. Perhaps it swipes away 6A, perhaps they fit together somehow, as Mr. Cohen suggested. But the critical point is that even if there is even if regulation 36(6)b is engaged in respect of the latest tenancy, it was still engaged anyway in respect of the earliest tenancy.
But for the point of no significance in this case, you have to go a stage further, do you, and say that the breach of the law which would have occurred in relation to the earlier tenancies
Is a prescribed requirement.
Yes.
Yes, and I do. So if we, having established that regulation 36(6)b would have applied before the tenant first went into occupation, so in our case, 2007. If we then look at the 2015 regulations on page 109, Parliament has made it a prescribed requirement for the purposes of section 21A that the landlord has complied with paragraph 6 of Regulation 36. So what that does is simply to import on Mr. Cohen's case his meaning of Regulation 36(6)(b), which is that it's a rolling obligation every time there's a new tenancy. And what that does is incorporate as a prescribed requirement the requirement to have given under 36(6)(b) the last gas safety record made before each new tenancy, including the first one.
But surely that is subject to Regulation 1 sub 3. It doesn't apply. Those regulations, that importation doesn't apply in relation to pre-2015 tenancies.
My lady, that's a brilliant point.
But just generalising, I might quite follow this point in this case. So suppose one had a succession of post-2015 ASTs.
Yes.
You say Mr. Cohen's construction would mean that a landlord wouldn't be entitled to serve a Section 21 notice if there had been a failure to produce the pre-occupation GSR in relation to each of the tenancies.
Exactly.
That sort of seems to prove too much. I mean, you obviously don't accept Mr. Cohen's case, but I mean, suppose, to take different facts, somebody goes into occupation as a tenant once or twice, then he goes away for a couple of years, comes back.
Yes.
At that stage, there's a new tenancy. Well, plainly at that stage, we're into the territory of the pre-GSR, pre-occupation GSR. But supposing that there have been failures in relation to unconnected earlier tenancies, you wouldn't say that precluded the service of a Section 21 notice in relation to this latest tenancy, would you?
Well, if Mr. Cohen is correct, I suppose that would follow as a natural consequence of that interpretation, but that absurdity would be a reason why, in my submission, Mr. Cohen's interpretation of occupation ought not to be preferred.
I mean, would one at least say, or can Mr. Cohen at least say, well, look, plainly that argument can't work in relation to discontinuous tenancies. Or to put it another way, while you might still have breached Regulation 36 in relation to each individual tenancy,
yes,
actually on Mr. Cohen's case, it's a failure in relation to this tenancy that matters and nothing else.
Yes, well, perhaps that is right, because I suppose if the tenant has gone out of occupation for a period of years, then they are no longer concerned with the safety of the gas fittings from many years ago when they were last a tenant. But if they are back into occupation as a new tenant under a later string of tenancies, in Mr. Cohen's case, Regulation 36(b) refreshes. Say they're given a fixed term tenancy every year, period of 5 years. Instead of Regulation 36(6)(a) doing the work, Regulation 36(6)(b) does the work. So I suppose a consequence of that might be that the conundrum that flows from the Respondent's notice analysis in Trecarrel is to some extent wiped away, because it does crystallise an obligation annually, whereas on Law Justice Patterns analysis in Trecarrel, if you don't do your annual check within 12 months of the last, it doesn't matter, you can make that good. But yes. So mindful of the point that my lady just put to me, I think actually I have to, on a different case, it might not provide a complete answer.
It would be an answer to both appeals in this case. It would be relevant on the facts of both cases before this court today.
Well, given that both...
because both of them, if you like, start pre-2015.
They do. But if... Yes, sorry, no, in fact, if I can... Brilliant point I thought, or my lady had put to me. Actually, just if I may just step back and have another go at it. The regulations apply... Well, it is the same point I was looking at. The regulations apply to a short-term tenancy after the 1st of October 2015. So all the regulations do is make a prescribed requirement bite on the right to give a Section 21 notice under the latest tenancy. So that is consistent with what I'm saying, because what it does is then imports, on Mr. Cohen's case, all of the obligations under Regulation 36(6)(b, going back to first occupation. So it wouldn't make a difference to the outcome in this case because it was a prescribed, it was a requirement under Regulation 36(6)(b) to have given the preoccupation GSR on this appeal in 2014 in the Muca appeal, in the Muca appeal of 2014. That hasn't been done, and the landlord hasn't complied with a requirement that is prescribed as a precondition of being able to serve a Section 21 notice in relation to the latest tenancy. Anyway, there's some food for thought there at any rate. I've addressed it in writing. I'm mindful of the time, so I haven't got a huge amount more to say. Just on interpretation 3, linguistically, with the greatest respect to the analysis of Her Honour Judge Melissa Clark, that doesn't work on the face of the 2015 regulations, which prescribes as a requirement both A and B. Her reading is that you don't have to worry about B when there's been a landlord and tenant relationship for more than 2 years. That involves making 36(6)(b) not a prescribed requirement, which is exactly what the Court of Appeal said you can't do. So I'd invite the court to reject that interpretation. Very briefly on the various presumptions upon which Mr. Cohen relies.
I certainly think you will have to be brief to allow Mr. Decker his due time.
Well, suffice them to say, my lord, they are simply presumptions. They are no more than that. They are obviously to be displaced by clear language, and in the case of a legislative scheme such as this one, Parliament can be taken to have intended to interfere to some extent with landlords' property rights. It's a policy decision it's made, and the proportionality, invite the court to keep in mind, proportionality of the measure is of course relevant as it would be if the landlords were relying on their P1 rights.
Is there any learning in the case law in the field of landlord and tenant law along the lines of what I certainly come across in areas that I'm more familiar with, like employment law and discrimination law, where it's replete with case law which says this is social legislation, and far from these there being these presumptions that you don't interfere with property rights and things like that, actually the primary function of the court is to give effect to the benign social purpose of the legislation. I mean, I've said that, for example, in relation to the National Minimum Wage Act.
Yes. Well, if I can just, it's not quite in the landlord and tenant context model, but I can give one example of that in recent years, which is the behind tab 18 of the authorities bundle. It's the Darwall and Dartmoor.
Yes.
Which was the case about wild camping. My Lord Justice Newey will recall it, as I think he sat in this court. But what is significant is that in the Supreme Court, my head of chambers and I unsuccessfully persuaded the Supreme Court to overturn this court, but we also tried to rely on the principles against expropriation, the principles that a statute shouldn't interfere with property rights, and that was given a fairly short shrift by Lord Sales. And
what page is it?
So the bill I'm looking at, my Lord, is on page 386.
Thank you.
And it's paragraph 46. And really what the Supreme Court does here is to endorse what the Master of the Rolls said in this court. Since the words have a clear meaning, that meaning cannot be altered by the fact that the landowner's property rights are to some extent.
I understand all of that, and thank you for reminding me of that. It's still not quite getting at the point I'm getting at, which may be a bad point, which may be why it hasn't been made. But I mean, things like there are all sorts of pieces of legislation which, in one sense, interfere with the rights of those who have economic interests.
Yes.
But the whole point is that Parliament, our democratically elected
Yes.
Parliament, has taken the view that it's time to change. And what the courts have said frequently is that rather than giving narrow, circumscribed approach to such legislation, it should be given its full effect in a purposive way, because it's intended to have a social impact.
Well, I think Mr. Cohen accepted that in his submissions. Only once you get into a grey area, only where there is ambiguity, do any of these presumptions have any place. the passage I just showed you in double or double makes clear.
No ambiguity,
You
says Lord
construe the
Sales.
words. If there's no ambiguity, which apparently in the context of the Double Commas Act there isn't, if there's no ambiguity, these presumptions don't get off the ground. It's the words. And so, my lord, it is a good point. I can't point to any judicial expression which is put as eloquently as that, but it arises from all the authorities, and I think Mr. Cohen accepts that. That's right.
Thank
You construe the words unless you have not to. So I will then, unless there's anything else, give way to Mr. Decker. And it'd be remiss of me not to to wish him a happy birthday. I believe it's today.
Mr. Decker.
Yes, my lord, my lady. I don't intend to repeat the submissions that Mr. Cohen made on behalf of the landlord appellant in the Harker appeal, but to expand on the background in respect of both the factual background in the Muca appeal, which hasn't been canvassed by either of my learned friends, and also the background in respect of the relevant statutes and regulations. So the starting point in the Muca appeal is at tab 15 of the core bundle, at page 174. The relationship between landlord and tenant in this case started on the 5th of February 2014, when an assured short-hold tenancy was granted for a one-year term from the 5th of February 2014. So by virtue of Section 5.2 of the Housing Act 1988, a statutory periodic tenancy arose on the 5th of February 2015. What is notable about the 5th of February 2015 is that was prior to the 1st of October 2015, when the 2015 regulations took effect for the very first time. Albeit if the court looks at page 108 of the authorities bundle, that's tab 8. What we'll see at Regulation 1.1, as it's already been taken to, the regulations come into force on the 1st of October 2015, and then as noted extensively by Regulations 1.3 and 1.4, they do not apply to an AST granted before the 1st of October 2015 or a statutory periodic tenancy arising out of an AST that was granted before that date. Turning back to the core bundle at page 17, it's tab 2. The court will see the chronology of relevant events. So as I've taken the court to the first AST in 2014, the statutory periodic tenancy in 2015, line 3 says it's undated, but it should say 1st of October 2015 when the requirements come into effect. Then the court will see overleaf at page 18, and I'm referring to it in the chronology for sake of brevity. The first gas safety record in this relationship was issued on the 30th of October 2015 in respect of and at a time when the first statutory periodic tenancy was still in existence. So there was no requirement under the 2015 regulations. The 2015 regulations hadn't been imported into this relationship yet. Yet you see them activating compliance with the 1998 regulations. Nevertheless, a second gas safety record is done and provided on the 5th of December 2016. And then the court will see in the 4th line that the relationship changes again on the 5th of February 2017 when a second assured short hold tenancy is granted And the court will see that assured short hold tenancy, just for the note, at tab 15, pages 178 to 181. Unlike the first assured short hold tenancy, that had a fixed term of 6 months rather than 1 year. So statutory periodic tenancy arose on the 5th of August 2017 by virtue of section 5.2 of the Housing Act 1988. The court will then see, with the relevant page references in the third column, that a series of 8 further gas safety records, so the 3rd through the 10th gas safety records, were done and issued at various times between 2017 and 2024 annually, that they were reserved on the 10th of January 2025 and the 26th of January 2025, as my learned friends made clear, is regular practice before service of a Section 21 notice following Tricaro. And then the Section 21 notice itself comes on the 28th of January 2025, which the court will see at tab 15, page 183. Now, against that factual background,
Just before you leave that,
Yes.
by way of footnote, we were discussing earlier the fact that the legislation doesn't bite if you have a pre-2015 AST followed simply by a statutory periodic tenancy. So you come within the scope of this legislation because of the grant of the later 6-month AST.
yes, my lord.
Now, Mr. Morris says, well, you know, landlords might do that because they get an increase in rent. And here there was an increase in rent. So that would explain why they thought it was a good idea to swap to the contractual tenancy, I suppose.
Well, I would submit there's also a benefit for the tenant. By a landlord granting a new assured short hold tenancy with a fixed term, it's foregoing its right to end that tenancy on no fault grounds for the fixed term.
But only 6 months.
Only 6 months, but at least it's 6 months further that the tenant has security of tenure.
Yes, I see.
So here there obviously is the benefit of potentially rent being increased, but there's also the benefit in return, which is a further security of tenure.
Yes.
Now, the primary submission that I want to make in terms of the relevant background that the court will need to consider is that we're dealing here with restrictions on Section 21 of the Housing Act 1988 and not preconditions for an assured short hold tenancy. And what the court will see from the authorities bundle, and in particular tab 3 at page 25, Section 19A of the Housing Act 1988, as Mr. Cohen said, came into force from the 28th of February 1977, and from that date forward, the default tenancy under the Housing Act 1988 was an assured short hold tenancy rather than an assured tenancy, unless it falls within any of the paragraphs in Schedule 2A to the 1988 Act. Schedule 2A at page 66 of the authorities bundle provides an exhaustive list of tenancies which can be assured tenancies. There are preconditions in order for the assured short hold tenancies to be assured tenancies, and they're set out at Schedule 2A. If, for example, a landlord had not done a gas safety check prior to the tenant going into occupation, and by virtue of not doing the check, there was no record at all, then you might expect, if Parliament intended that in such a situation you would get an assured tenancy, that that language might find its way into Schedule 2A. Because it would create a situation where you don't have the short hold aspect of the tenancy any longer. And on the tenant's construction in these cases, could never get that short hold aspect back, no matter what, if it was never done. If I take the court's attention to tab 14 of the authorities bundle at page 254, actually, at page 257, what's said in Trecarrel at paragraph 40 is effectively that if this restriction is irremediable, you get, in the final sentence of paragraph 40, a fully assured tenancy with accompanying security of tenure. So in terms of considering Schedule 2A and the fact that an irremediable breach would lend itself to a fully assured tenancy, we would expect that such irremediable breaches found their ways into Schedule 2A. Now, if the court looks at tab 7, page 67 of the core bundle, I've tried to set out an exhaustive list of all of the restrictions currently in force in respect of Section 21. Again, these are not preconditions to an assured short hold tenancy, but restrictions on Section 21 itself. And I won't go through each one in detail, but what the court will gather is that in columns 4 and columns 5, for every restriction on Section 21, at any time that Parliament ever legislated, there is an opportunity to remediate the issue that gives rise to the restriction. And that is not dependent on the seriousness of that restriction either, because many of the issues giving rise to the restriction, for example, are also criminal offenses under the relevant primary or secondary legislation. And one key restriction that the court should have at the back of its mind when thinking about the one relevant to these appeals is on page 68, the core bundle, the third row down, which is retaliatory eviction, where the landlord is served with an improvement notice. In those circumstances, sections 33 and 34 of the Deregulation Act 2015 provide that the restriction on service of a Section 21 notice is only time limited, such that the landlord only need to wait 6 months before it serves a Section 21 notice. Now, what's important about an improvement notice is the local authority who serves the improvement notice has to be satisfied that there's either Category 1 or Category 2 hazards in the property. Category 1 hazards being very serious issues with the condition of the property, such that it might present immediate risks to human life and well-being. But there's no requirement here to even comply with the improvement notice. It's imposing a maximum wait period of 6 months, and then that's lifted for the Section 21 notice to be served. And the reason why that example is so relevant, one is because it's a very serious breach in respect of the condition of the property, and it may even relate to the gas safety, for example. But also, that restriction comes into play by the Deregulation Act 2015, which is the same amending legislation, the same part, in which Section 21A is added to the Housing Act 1988. So it's within the same realm of thinking of Parliament at that time. So if the court goes down to page 69, again, for sake of brevity, I'm not going through each one of the restrictions, but the court will see in the final row, where I've set out the failure to provide the last GSR to a new tenant preoccupation. If, for example, the tenant's interpretation is correct, then this becomes the only irremediable restriction on Section 21, and actually, by virtue of that, becomes a precondition for an assured short-hold tenancy. Now, I say in column 4 that this is irremediable where such a preoccupation gas safety record has been lawfully destroyed under Regulation 36.3, has been lost before it was served, or it never existed. But I would submit there's 7 scenarios where this would come into play on a spectrum of the most egregious breach of the regulations to the least egregious breach of the regulations, and potentially not even a breach of the regulations at all. The first scenario is that no check is actually done. And because no check is actually done, there can't be any gas safety record. The second is that a gas safety check is actually done in compliance with Regulation 36.3 A and B, A or B, but no gas safety record is produced. The third situation is where a check is done and a gas safety record is produced, but that gas safety record is not compliant with all of the relevant things that it needs to include under Regulation 36.3C. The fourth scenario is where a check is done, but a compliant gas safety record has not been served, preoccupation, and it's been lost. The fifth scenario is a check's been done, but a compliant gas safety record has not been served, but it's been lawfully destroyed under Regulation 36.3 after 2 years or 2 further checks were done. The sixth scenario is where a check is done, but evidence of a compliant GSR having been served at the relevant time is unavailable or no longer available, such that the landlord cannot discharge the burden of proof in respect of proving it at the relevant time. And then the fourth scenario is where a landlord exercised its right to delay completing the gas safety record under Regulation 36A of the 1998 regulations. The last point is something that hasn't been explored yet today, and I'd like to take the court's attention to it at tab 6, page 87 of the bundle. The authorities bundle. Now, under Regulation 36A, and in particular, paragraph 2, the landlord can, instead of checking it within the relevant 12-month period, delay that check by a 2-month period, beginning with the deadline date, if the relevant discretion arises under paragraph 3. And the relevant discretion is it can only be done once in respect to the relevant premises. And the purpose of delaying it is so that all of the appliances and flues are effectively checked at the same time. And then the court will see at paragraph 4 of Regulation 36A, the definition of deadline date, which is in relation to a safety check for the appliance or flue, means the last day of the 12-month period within which the check is or was required to be made under Regulation 36(3)A or B. Well, if the court turns back over leaf to page 83 of the authorities bundle, the relevant deadline date here is Regulation 36(3)B, which is in the case of a lease commencing after the coming into force of these regulations. Ensure that each appliance or flue to which the duty extends has been checked for safety within a period of 12 months before the lease commences, or has been or is so checked within 12 months after the appliance or flue has been installed, whichever is the later. So if the later is a period of 12 months before the lease commences, this allows a landlord in certain circumstances to delay that by 2 months. So if the court turns over leaf to page 84.
Sorry, just to be clear, how do you say that works in relation to a lease that is beginning? A period of 12 months before the lease commences.
Yes.
What does it become instead?
So the deadline date under Regulation 36A is the last day of that 12-month period, which would be the date of the lease commencement. So it would be extended in certain circumstances by discretion by 2 months. So in some circumstances, you might have the provision of a gas safety record and a gas safety check that's entirely compliant with the regulations, but at least one part or one of those gas safety records crosses the threshold of when the lease commences.
Yeah.
It's presumed, effectively, that the tenant goes into occupation at least on the first day that that lease commences. So if the court turns over leaf to page 84 of the authorities bundle, where the requirement is that the landlord shall ensure that at Regulation 36(6)B, give a copy of the last record made in respect of each appliance or flue to any new tenant of the premises to which the record relates before the tenant occupies those premises. the issue is that there may be records in respect of some or more of the appliances or flues that will not have been made lawfully prior to that tenant going into occupation. So I think the interpretation that's been assumed in Trecarrell and in some of the county court decisions that have been put before this court is that Regulation 36(6)B, a copy of the last record, means that there will always be a last record, or there has to be a last record. But as Mr. Morris submitted during his submissions in respect of Regulation 36(6)A, and how the court approached that in circumstances where the record hadn't been done at intervals of exactly 12 months, well, if you didn't do it, one just does it and comes into compliance. If one did it and lost said record, then that record doesn't exist anymore to give to the tenant, and therefore there's no longer a requirement under Regulation 36(6)A. In the same way that I would submit that if there is no record under Regulation 36(6)B to give, because that last record wasn't done, including in compliance with Regulation 36(A) before the tenant occupied those premises, or because it didn't exist, or because the preoccupation gas safety record wasn't compliant with Regulation 36(3)C, for example, then there was no duty that was arising under that subparagraph.
If there has been an extension under 36(A),
Yes.
and the tenant goes into occupation before the end of the extended period, is there any obligation to serve anything under B?
Under B, there might be an obligation to serve a gas safety record in respect of certain other appliances or flues that had been done previously. But the key wording of subparagraph B is that it says in respect of each appliance or flue. There's not a carve out for Regulation 36(A), but the court sees the carve out for Regulation 36(A) actually in Regulation 36(3)A and B, where the final words are "and see Regulation 36(A).
I mean, just supposing for the sake of argument that in relation to a particular appliance, it was the case that the deadline had been extended, so that by the time the tenant went into occupation, there was no obligation under 36(3) to serve, to get the check, and therefore no obligation to serve any record under 36(6)B, then would it be the case you would not in fact be caught by Regulation 2 of the 2015 regulations anyway? Because you wouldn't in this respect have failed to comply with paragraph 6, because paragraph 6 wouldn't have obliged you to do anything.
Well, paragraph 6 requires the last record made in respect of each appliance or flue. And in circumstances where you didn't have a duty to produce it in respect of certain appliances or flues, you couldn't actually comply with that because there is no record.
But maybe you're not obliged to do it, in which case there isn't really a problem anyway.
Well, that goes to my point of interpretation, which actually this is one scenario where Regulation 36(6)B creates an actual impossibility in certain circumstances. And if I take the court's attention...
Well, maybe it just doesn't bite.
Well, it's a copy of the last record made in respect of each appliance or flue. If, for example, no record was done either in exercising the discretion under Regulation 36A, or not done at all, then arguably the not done at all would also lend itself to the same interpretation, because there is no last record to actually serve, because no record was actually done.
Yes, I see.
So last record presupposes the existence.
Well, I can see that in circumstances where, as my lord says, the legal obligation to produce the record never existed, then there's nothing for this provision to bite upon at all. But I think you seem to be taking that a step further and saying that even though there was an obligation to produce it, but that obligation has been breached, if in fact no such record exists, then this provision doesn't apply. Is that your submission?
That's my submission in respect of the importation of this regulation to the 2015 regulations.
Yes.
So if the court looks at page 109 of the authorities bundle, which is the regulation 2 of the 2015 regulations, as at the date that one is coming into compliance or potentially late compliance under the 2015 regulations, if that last record no longer exists, because it wasn't done, it was lost, it was lawfully destroyed, etc., then that regulation 36(6)(b) doesn't have a relevant record anymore, because that record simply doesn't exist.
Well, you say anymore, but actually your submission would apply even where it was never obtained. Is that right?
Yes, in respect of the 2015, how the 2015 regulations defines the relevant record. The relevant record being, and what's key here is regulation 2.2. For the purpose of section 21A of the Act, the requirement prescribed in paragraph 1B is limited to the requirement on a landlord to give a copy of the relevant record to the tenant. So that limitation of the relevant record is the relevant record at the time that it may need to be given under the 2015 regulations. And if that record doesn't exist, because it wasn't done, either lawfully, unlawfully, gotten rid of, destroyed, etc., then there is no more requirement for that. In the case of Trecarrel, the pre-occupation gas safety record did actually exist.
Can I just, I'm not sure I've caught up with this argument properly. So suppose a landlord does absolutely nothing, never carries out any check at all, never makes any records at all in respect of a pre-occupation check because there wasn't one, and makes no records in relation to later checks because there weren't any. How does regulation 2 of the 2015 regulations bite, or doesn't it?
The language of regulation 36(6)(a) and (b) might be relevant, where in A you get a copy of the record made pursuant to the requirement.
But if there isn't one, because they never did anything.
Well, I think the 2015 regulations assumes that there must be at least one, because there must be the giving of at least a relevant record. Just to flag, that goes in terms of the ambiguity in construction, it goes to the presumption against impossibility, which the court will see at page 455, tab 20 of the authorities bundle. Presumption against absurdity means the courts will generally avoid adopting a construction of an enactment that requires a person to do that which is impossible. And actually, the example given at the bottom of page 455 the court will see a scenario that was played out where Lord Justice Dyson observed in respect of certain statutory requirements to provide copy documents of something where the applicant could not obtain those copy documents for a certain reason. And it couldn't be that the statute was interpreted such that that person couldn't rely on the challenge, in this case, the application to change the status for right of way because they couldn't get a hold of those copy documents.
On your submission, would this presumption apply even where the relevant person has made it impossible because of their own conduct?
Yes, in circumstances where the 2015 regulations come into force on the 1st of October 2015, and so for a period of 25-something years, there's no suggestion that the not obtaining such a record would lead to the irremediable restriction on Section 21 once the tenant went into occupation. And what's also important in this case, and the reason why I went through some of the chronology, is from the commencement of the 2015 regulations in respect of ASTs after that day, on the 1st of October 2015, there are 10 gas safety records that are done annually every single year. And what the tenant's construction creates is a situation where perhaps the landlord didn't do the gas safety check or record pre-physical occupation, but then did 10 gas safety checks and records thereafter for 10 years thereafter, and then cannot rely on Section 21. But on the flip side, a landlord who did the pre-occupation gas safety check 10 years prior, then did nothing for 9 years, and then did one in the 10th year, would then be able to rely on Section 21. And that leads into a segue of my last point on the relevant background overall, which is the purpose of the 2015 regulations themselves. The purpose of the statutory drift in the Deregulation Act 2015, and in particular the 2015 regulations that come out of that act, is the bringing of the landlord into compliance with his or her statutory duties and obligations under other acts of Parliament, and as Mr. Cohen said, in respect to the 2015 regulations, the whole purpose is to get the landlord to have the records and then to give them, and nothing beyond that. And I give two examples that highlight my broader point, which I'll make in a second, which is, let's suppose a preoccupation gas safety record had actually been done and exists, but it had not been given for the last 11 years, and it's given right before the Section 21 notice. What benefit is there to the outgoing tenant to be notified of the gas safety position before they went into physical occupation 11 years prior? What benefit is there to the tenant of even the most recent gas safety record if they're threatened with a possession order within shortly after 2 months? What is the benefit of getting an EPC certificate about the environmental performance of their property right before they're about to leave? There is no obvious benefit. But what is the benefit to the incoming tenant after that assured short hold tenancy is ended? Well, in respect of all of the Section 21A requirements that become restrictions, the property's safe when they take up occupation as a starting point. The landlord is aware what works it might do to make the property more energy efficient, for example, prior to that next tenant coming in. And as regards all restrictions on Section 21 generally, it gives the landlord an awareness of all of their duties and obligations under all of the relevant primary and secondary legislation. And also, it creates a situation in terms of timing where that landlord, in respect of the next tenant, is no longer in breach of its statutory duties or obligations in respect of the relevant time periods that actually bite in the legislation, primary or secondary, in respect of each one of those duties themselves. So whilst the restrictions strip back the time period of compliance, as in you can do everything all at the last second, by forcing the landlord to do everything at the last second, it ensures that in the transfer of the tenancy, there's going to be a landlord that's aware of his or all of his or her obligations and a tenancy that's in full compliance. And the best example of that, for example, is if there's been, if for example, there's a house in multiple occupation that requires a license. Well, in order to serve a Section 21, one need not actually obtain the license, but just make an application for it. What benefit does that have to the outgoing tenant? No benefit at all. The local authority might not even inspect the property before the tenant is evicted under Section 21. But what benefit does it have in respect to the incoming tenant? A lot, because then that property is put under scrutiny by the local authority. And in addition, by requiring it to be done before the Section 21 notice is served, it made the landlord aware, if he or her was not already, or he or she was not already aware, that he or she needed a license. I don't intend to go into each one of the relevant interpretations because the court has heard expansive submissions on those, and I'll reserve my time to Mr. Cohen to reply in respect of them. But the key point in relation to this appeal against the other appeal is that there were findings by the judge below, and in particular at paragraphs 55 and 56 of the judgment on page 101, where although the transcript is not clear in respect of paragraph 55,
This is where an extra words have been
yes, extra
attributed
words
to the
come at the
quotation.
end, where the judge was rightfully referred to the correct quotation. In effect, the judge below found two things.
So just to be absolutely clear, if we have paragraph 55,
Yes,
the quotation ends after is it as the regulations themselves, and the next bit is actually the judge.
yes. Let me just... Yes, so that also supports, in my view, should be a new paragraph.
And by the time the judge came to approve this judgment, he'd forgotten that that was how it worked.
Yes.
Yeah.
Of course, this appeal being expedited and but effectively, what the judge below found was two things. The first is that if the landlord was the landlord of an existing tenant when the 2015 regulations came into force, then the relevant record within the meaning of the 2015 regulations was regulation 36.3a only. And that creates the sort of hybrid analysis that my lady mentioned in terms of the reading of the relevant record from the 2015 regulations into the 1998 regulations, where there's an absurdity that's created where if the landlord just kept the tenancy under the statutory periodic tenancy, the first statutory periodic, it would have been able to rely on Section 21 to end the relationship between the landlord and the tenant. But by granting the second assured short-hold tenancy, created a situation where on the tenant's construction, it could never actually end that tenancy ever again. And then the second point that the judge below makes at paragraph 56 is that if the judge was wrong about that, then the relevant record is the most recent record before the second assured short-hold tenancy and the most recent before the Section 21 notice. The second point of that not being in contention in this appeal, the relevant record before the most recent, or before AST2, we've expanded to also be the second statutory periodic tenancy, depending on how occupation is construed in Regulation 36. As Mr. Cohen noted, it's notable that statutory tenancy doesn't include a statutory periodic tenancy under the Housing Act 1988, in which case it might be AST2, but alternatively under our second respondent's notice ground, it could be the second statutory periodic tenancy. In any event, on the facts, it doesn't matter because it's the same as in the case of Tricaro. It's the same pre-occupation gas safety record, whether or not it's vis-a-vis the second assured short-hold tenancy or the second statutory periodic tenancy. The last thing I'll conclude with is just the facts of Tricaro itself in terms of understanding what the ratio might be. And just a timeline of them again. The assured short-hold tenancy commences on the 20th of February 2017. That's an assured short-hold tenancy for 6 months, which means something happened on the 20th of August 2017. We don't know if it's a statutory periodic tenancy that arises under Section 5.2, a contractual periodic tenancy, for example, where there was a fixed term and then from month to month thereafter, or the grant of a new AST. It's simply not said in the facts. The first and preoccupation gas safety record in issue is dated the 31st of January 2017. That's given to the tenant on the 9th of November 2017. There's a second gas safety record that's done on the 2nd of February 2018. And the Section 21 notice comes on the 1st of May 2018. What's quite important is if the turning of the tenancy at the 20th of August 2017 has relevance, then the time limit for complying with regulation 36(6)A could have gone as far as the 20th of August 2018, which is after the Section 21 notice is served. If it was run strictly from the date of statutory tenancy. Unless I can assist further on a specific point, I'll just conclude by saying and echoing what's said in Tricaro, that each one of these restrictions is at best a spur to compliance. They're not preconditions to get in a short hold tenancy. And in those circumstances, any one of the interpretations offered should be the right outcome.
Thank you very much, and for being economical in time terms. Mr. Morris.
One thing, my lord, just on regulation 36(3)B. So looking at page 83. George's bundle. So what this provides, the landlord shall, in the case of a lease commencing after coming into force of these regulations, ensure that each appliance and flue to which the duty extends has been checked for safety within a period of 12 months before the lease commences, or has been or is so checked within 12 months after the appliance or flue has been installed, whichever is later. The word later refers to the date either of the commencement of the lease or the date of the installation of the gas appliance. So there will always be a pre-occupation gas safety record where the premises contains an appliance or fitting to which the duty extends before the lease commences. The second bit of that paragraph is engaged only if, on the date of the commencement of the lease, there isn't a particular flue or fitting installed to which the duty extends, and one is subsequently added to the premises. The only other thing I would say is that my Lord Justice Singh asked if there was some authority in the landlord-tenant context. I have found one, and it's a case called Cardigan McGurk, which is about the same act as Lord Justice Buckley was commenting on in Methuen and Campbell's, Methuen, Walton Campbell's, and all that is said there. This is Lord Justice Millett. Says two particular questions were canvassed. The first was whether the act, being expropriatory in nature, must be strictly construed. A man, it was said, is not to have his property compulsorily acquired except by plain language. He gave some examples of people doubting that, and he said, I respectfully agree. It would, in my opinion, be wrong to disregard the fact that while the act may to some extent be regarded as expropriatory of the landlord's interest, nevertheless, it was passed for the benefit of tenants. It is the duty of the court to construe the act fairly with a view, if possible, to making it effective to confer on tenants those advantages which Parliament must have intended them to enjoy. So different context, but there we go. I hope that's a nice clear expression of the principle which my Lord was putting to me, that I've nothing to add.
Mr. Cohen.
My Lord, I'll only be very brief. That's my reply.
We won't object to that.
I'm sure not. The first point is just a point of correction, which is in respect of the Section 8 ground date claim that my client has. I understand that the arrears have been paid, so there is no possession so far as that alternative claim is concerned. The next is I have with me copies of an authority called Church and Murphy Tidfield from 2023, which has a very neat summary of what ratio in terms of authority actually means, paragraph 17. I'm sure you're all very familiar with it, but if it would help, I'm very happy to hand it up if that would assist.
In circumstances where you have them there, can we please have the copies?
Of course, I don't intend to make submissions of them, and that's my friend. paragraph 17 explains what ratio actually means so far as this court is concerned in that case. As it says, paragraph 17, taking from the comments of Lord Justice Later.
Paragraph 17.
Paragraph 17.
And it's your case that Trecarroll, it's obviously your case, it's your case that Trecarroll does not apply just to decide against you.
Indeed not. In the submissions that I've put to this court, both 1, 2 and 3, none of them form any part of the court's, to take the words italics from paragraph 17, as being part of the best or preferred justification of the conclusion reached. So far as interpretation 1 is concerned, my lord, you will have heard that in my submission those arguments were not put to the court. What was put to the court was that regulation 36(6)(b) did not apply in its entirety, and the words in its entirety appear 4 times in the judgment. Whereas I say it does apply, but of course when one goes beyond the first 12 months of the term, it's then superseded by events, because the notice is then to be given under 36(6)(a). With respect to interpretation 2, what Mr. Morris says is, well, the reason why that was addressed in Trecarroll was because there was an original 6-month term, and thereafter the occupation continued. One, I think, supposes that it was a statutory continuation tenancy. And what is said is that is a new tenancy, and yet the Court of Appeal was still concerned with the occupation certificate prior to the 6-month grant. The answer to that is the statutory continuation tenancy was not a new tenancy. Under the 1998 regulations, the lease is less than 7 years, a periodic term by way of grant or a statutory tenancy arising out of the Rent Act. So the Housing Act statutory continuation tenancy was not a new tenancy, full stop, because it does not fall within the definition of lease. So factually, in my respectful submission, that point simply didn't arise before the court, irrespective of the fact that a lot of this is simply a function of conjecture and speculation, because we have no idea of the basis upon which the tenants remained in occupation after the end of the fixed term, simply because there's no point that was taken before the court so far as that is concerned.
But wouldn't your main point on interpretation 2 be the same as interpretation 1? It's not for the reason.
It is. It's exactly that. It's just my left friend, Mr. Morrison, has made the point that actually the facts are traversed in Trecarroll, and that's in support of his submission that if an argument is not put, it doesn't necessarily mean that one can designate the decision as per curiam. And what I'm saying is the arguments were absolutely not put, but nor do the facts even arise in that case, so as to engender the argument itself. So far as interpretation 1 is concerned, was said by my then friend, Mr. Morris, is that the expression relevant record in the 2015 regulations means relevant record from, in a sense, relevant record as time continues. So a relevant record doesn't mean a specific record as at the date of section 21 notice, but simply means there are various stages in which there will be a relevant record. That is how I understand the submission to be put. The answer to that proposition is the fact that section 21A focuses attention at a specific point in time. And Regulation 2.2 of the 2015 regulations makes it clear, as one would expect, that the requirements prescribed for the purposes of Section 21A are as follows. And it's Section 21A that asks the question with reference to a specific moment in time, and it's for that reason that the relevant record as an expression is used in 2015 regulations, because in accordance with interpretation 1, at the specific point in time, it says, as you will know from Section 21, it's at a time when the landlord is in breach of prescribed requirements. So one looks at the date of the Section 21 notice and then identifies whether the relevant record has been given as at that date. And that's why in my submission, the relevant record is the expression that's used in Regulation 2.2. So far as interpretation 2 is concerned, my friend Mr. Morris accepted, I think, that even his preferred construction involves interpolating words into Regulation 36(6)(b), and the words that are lighted on by my learned friend are for the first time as a tenant. So the words that, certainly my note of his submissions, were that the words to be interpolated after tenant occupies those premises are for the first time as a tenant. Now obviously the self-evident proposition that comes from that is that where both parties are interpolating words, it's obvious that the terms self-statute under consideration are ambiguous, and then it's a matter of measuring up in accordance with the principles of Benyon on absurdity that I took this court to, which of those two lead to a solution which is more unworkable than the other, so to speak. But there is also another problem in my submission with the interpolation of the words for the first time as a tenant. That comes from the definition of tenant itself. Tenant is a defined term. And so if one looks at page 83 of the authorities bundle, tenant means a person who occupies relevant premises in England and Wales, where the relevant premises are so occupied under a lease, means the person for the time being entitled to the term of that lease. Now, if the definition of tenant is this definition, and by tenant I mean the word that's being interpolated by the respondent, one gets exactly the same definition as interpretation 2. Because to read it in full, in a copy of the last record made in respect of each appliance or flue is given to a new tenant or premises to which the record relates before the tenant occupies those premises for the first time as tenant, and tenant means that you have got to be occupying pursuant to the lease under consideration, in which case it gives rise to exactly the same definition as the interpretation 2 that the landlords put forward, which is that you are occupying for the first time pursuant to the tenancy that renders you a new tenant. So for that set of wording to give rise to the outcome that the judge and the respondent in my appeal seeks, the word tenant cannot have the same meaning as the definition in the statute. And there is also another consequence to that, which is if the word tenant, when the words for the first time as tenant are being interpolated, if they don't take from the statutory definition earlier on in that regulation, then what one can't have is the expression new tenant having the same meaning, which is a non-specific meaning, as the interpolated word tenant. Because if that were the case, then neither of the landlords in these appeals would be a new tenant, in which case there was no obligation on them whatsoever to serve a notice. So if one takes the word tenant and uses the statutory definition, then the respondent's interpolated wording means the same thing as the appellant's, And if that is not to be the case, so tenant is meant in an abstract sense rather than being referable to the lease that gives the right to occupation at the point in question, then that word tenant cannot mean the same thing as new tenant, because if it did, neither of the tenants in question would be new tenants, in which case there'd be no obligation on the landlord to serve notice on them at all. And that's what happens when.
Sorry, I don't think I follow that last part.
So, forgive me, I'm clearly not expressing myself properly. If one looks at Regulation 36(6)(b), the obligation on the landlord is to give a copy of the last record made in respect to each appliance or flue to any new tenant. Now, if you look at that expression, new tenant, and you don't take the definition of tenant, which anchors it to the lease and just takes it in the abstract, then in these circumstances, neither of the tenants were new tenants.
Why is that?
Because if it's divorced from their right of occupation, the fact that they would already be there, which I think goes back to my earlier exchanges with my lady, would mean that they wouldn't actually be new tenants because they'd already been in occupation prior to the point at which the final AST in question was granted in both cases. If one looks at the expression new tenant, there's two ways of looking at it. One is to say you're a new tenant because there's a new tenancy. Another way is to say you're a new tenant because there has not been a tenancy before. And they're subtly different. Now, because of the definition of tenant, interpretation 2 proceeds on the basis that you're a new tenant because there's a new tenancy. But if the definition of tenant is not to be taken, and instead it's meant in an abstract sense, then in both of these cases there'd be no obligation to serve any form of record if new tenant is meant to mean there has not been a tenancy before. And I think the core point to take from this is you cannot have on the respondent's tenant's case the same definition of new tenant and for the first time as tenant, because if it's the same and takes from the statute, then it's the same as my client landlords. And if it's the same as the respondent tenant puts forward, which is the abstract, then the tenants are not new tenants because there was a tenancy before. And it's for that reason that interpretation 2 proceeds on the basis that you're a new tenant because it's pursuant to a new tenancy, rather than saying you're a new tenant because you haven't had a tenancy before. If it were the latter, then of course there'd be no obligation to give gap safety record in either of these appeals because there had been a tenancy before. But as I said, they're two subtly different definitions of new tenant. One is anchored in the statute and one is anchored in the abstract. But if you take the words that are being interpolated by the tenants, which are anchored in the abstract, then you're going to have tenant meaning two different things over the course of 2 lines, because they cannot take it from the statutory definition, because that means the same thing as what interpretation 2 means, which is that you occupy for the first time as tenant pursuant to the new lease, because of the definition of tenant is indelibly anchored to the lease that gives you the right to occupy for the time being. The final point I will make, if I may, responds to my friend Mr. Morris's point about the idea that if interpretation 2 is to be preferred, it's incumbent on my client to have complied with prescribed requirements relating back to previous tenancies, in which case we'd end up in the same situation. So it is said by my own friend. The answer to that respectfully is that the 2015 regulations provide that the requirements prescribed for the purposes of section 21A. So what one then has to do is to go back to section 21A, and section 21A in turn refers to a notice under subsection 1 or 4 of section 21 may not be given in relation to an associated tenancy of dwellings at a time when the landlord is in breach of prescribed requirements. And the definition of landlord then borrows from section 21, 1 and 4, and it's the landlord under an assured short-hold tenancy to recover possession of the dwelling house let on the tenancy. So the landlord has got to be in breach of the prescribed requirement relating to the AST that the order for termination under section 21 is sought in respect of. Again, landlord is not an abstract term. It is tied in section 21 to the section 21 4 28, page 28. It is expressly tied to the AST for which the order of possession is intended to terminate.
I'm sorry, which provision is it in 21?
It's 21.1. Without prejudice to any right of the landlord under an AST to recover possession of dwelling house let on the tenancy in accordance with chapter 1, on or after coming to the end of an short-hold tenancy, which was a fixed term, the court shall make. And what one sees there is the linkage between the landlord and the tenancy, which is the object of the notice that's being sought. So what that means is the proposition that the prescribed requirement means that one needs to give 10 years worth of notices doesn't bite, because the prescribed requirement is subject to section 21A. 21A uses the term landlord for the time being. Landlord is then referred back to section 21 by 21A, and that's landlord of the AST in respect of which the
Sorry, I wasn't keeping up. Where do we find a definition of landlord?
I think that there's almost certainly going to be a definition.
But, yes, I see. So you're not making a point about a definition provision. You're...
No, what I'm saying is 21A refers to landlord in the context of section 21.1,
Yes.
and there's section 21.1 that talks about landlord of the AST, which is to be determined by the order of possession. And that's the answer to the proposition that one needs 10 years worth of notices. In my